Okay, are you James You're James Gwatney?
Yes, ma'am.
And Ms. Holmes, will your client waive the formal reading of the indictment?
Yes, Your Honor.
Right away, we're seeing something important. When a defendant waives the formal reading of the indictment, it usually means this isn't their first conversation about these charges. The paperwork's been reviewed, the strategy's set, but here's the real question for you watching when someone pleads guilty this quickly. Is it accountability or damage control?
Mr. Gwatney, in clause number 25, DCCR 0736, you're charged with a third-degree felony offense of failure to comply with sex offender registration requirements.
I guess guilty is a red flag in court. Judges have to make sure a plea is clear, voluntary, and intentional. There's no room for uncertainty when you're giving up constitutional rights. Notice how the judge immediately tightens that up. This is about protecting the record and preventing appeals later. But emotionally, that pause...
And that's from March 5th of 2025. And how do you plead to that charge?
I guess guilty.
Well, there's no I guess. Either you did it or didn't do it. So are you guilty or not guilty?
Guilty.
Are you entering your plea of guilty freely and voluntarily? Answer out loud, please.
Yes.
Did anybody force you to plead guilty today?
No.
Okay. I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
And just like that, it's done. 2 years in TDCJ. Notice how structured this is. Competency confirmed, plea accepted, sentence imposed per agreement when there's a negotiated deal. The judge either follows it or rejects it entirely. Here, she follows it. But here's something. To think about, did he fully grasp that once she says guilty, the door to appeal is basically shut?
Yes.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Gwatney is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, and at this time find you guilty of failure to comply with sex offender registration requirements, sentence you in accordance with your agreement to a term of 2 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I've handed you the trial court certification that shows that this was an agreement that I followed, so you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition.
This is the moment of realization after sentencing. Defendants sometimes start processing what just happened. But here's the harsh truth once you plead guilty. Procedural complaints about timing usually don't undo the conviction. The judge's response is blunt because legally, the case is closed. Question for you, should courts slow things down? More to make sure defendants truly understand the timeline?
Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Holmes. All right, good luck to you, sir. You can go back with the bailiff.
Can I ask you one question?
Sure.
Whenever I was brought back from Oklahoma, I had 6 months left on my 3-year sentence. They sentenced me to ISF until discharge. Why was this charge that is being brought up on me now not brought up on me while I was being incarcerated back in ISF for the last 6 months?
How would you think I would know that information? I have no idea. I have no idea. I
have gone over the time frame with him. From what he told me, the time frame that he was in ISF was after this case was filed.
Yeah.
This case has been indicted over 6 months.
Yeah. I don't know. I don't know why that didn't happen, sir. I'm not sure if it was something.
Charges were supposedly filed in June of 24, and I was arrested in 25 5.
These charges are from March of 2025, sir. And you
25.
just pled guilty to that and it's done. You got your 2 years. You can go back with the bailiff, okay?
Okay.
I don't know the answers to those questions. Good morning. Are you Luther Sharp?
Yes, ma'am.
And Mr. Sharp was previously in court in cause number 25 DCCR 0916, entered a plea of guilty to aggravated assault with a deadly weapon. The agreement was for a cap of 15 years in prison and a dismissal in cause number 25 DCCR 0917. I've received the pre-sentence report, and have you both had an opportunity to review that report?
Yes, Your Honor.
Yeah, sure. Yeah.
Are there any additions or corrections to the pre-sentence report?
No, Your Honor, I would note for the court, we did receive a follow-up memorandum after the PSI was created. The probation department was able to get in touch with the complainant in this case, and they echoed their agreement with the 15 years.
Okay. I don't see that I have that, but have you had an opportunity to review that?
I don't think I got that.
I received it on an email.
From probation?
Yes, sir.
Luther Sharp. But it's stating that the family
That the
is
victim of the
victim
shooting
is,
urged the full 15 years, Your Honor. They weren't
Okay.
agreeing on the deal.
all right. I also have received numerous letters that Mr. Vasquez has provided on behalf of Mr. Sharp. Mr. Nichols, were you given a copy of those?
I was, Your Honor.
And then, in addition, there are jail incident reports. We've talked about those in the past, and I have any updated ones. Have y'all had an opportunity to review that as well?
I have, Your Honor.
Yeah, sure.
Okay, then, Mr. Vasquez, you may proceed.
Judge, it's just a typo on the first page under defendant's version, first sentence, first line. Then it says, I got 2 bikes I got out of Louisiana. I'm sure the court could get that out of the context, but
Okay, they weren't trikes, they were bikes. I mean, there's such a thing. I think
Trikes.
they were trikes.
Yes, ma'am.
I don't know what trikes are.
3-wheel bike.
Well, then I withdraw my
Thank you.
typo correction. I beg your pardon. I should have known Justin doesn't make any mistakes. Judge, I know the court said you have all the support letters. I would just urge the court to sentence Mr. Sharp to something less than the 15-year cap.
Do you have a copy of this? Can you print him one? Give me just a second. I'm reviewing that updated, the memo. I want to make sure I've read that since it has the interested party victims statement. I'll give you a copy too, Mr. Vasquez.
Thank you.
That's impact. The judge reframes the entire case in one sentence. Lucky you're not here on a murder. This isn't just about a fight, it's about firing. A gun twice at someone. In sentencing, judges weigh criminal history, intent, and harm caused. And with his record, the court is signaling this could have been much worse.
right. Anything else, Mr. Vasquez?
There you are.
Mr. Nichols?
Your Honor, with his criminal history, urged the court to exercise the full 15 years under the agreement. That agreement, I think, reflects any consideration and an effort to. I mean, he did admit to it, and that's why. Okay, it's lower than it would be otherwise. With his criminal history, he was looking at habitual enhancement. He had not been off of parole, I think, for too very long. Only the last few years. He was last sentence expired in 2018, and by his own admission, he was doing cocaine. He caused a disturbance at the house when he was kicked out, so he shot the home, the resident of the home. I'm asking for the full 15 years.
Thank you, Mr. Nichols. Mr. Sharp, you're lucky you're not here on a murder over a bicycle tire.
Yes, ma'am.
I mean, you went over there with a gun, so it makes me feel like there was some amount of, I don't know if I want to use the word premeditation, but obviously some sense that you were going to cause issues or use that gun to show up just over somebody who was fixing a bike or a bicycle tire. Your last sentence was for 20 years. You received a 30.
The full cap under the agreement. And here's what stands out: the judge emphasizes the deadly weapon finding. That carries serious parole consequences in Texas. This wasn't just punishment, it was a message. When someone with a long criminal history picks up a gun again, the system runs out of patience. Final thought: was this justice served, or was it inevitable given his past?
30-year sentence back in the 90s. I mean, you've been in and out of prison since probably you were a young man, and the nature of this offense and what now this man has to live with based on the injuries that you caused. I mean, he was, when I say it's lucky it's not murder, it's not like you shot at him, you hit him twice.